This is Lance LoRusso. Welcome to the Blue Line Lawyer Institute podcast. Our podcast today is the ultimate immunity battle, how to rewrite the rules to win. We like rewriting rules. We don't play well by rules. That's why Ken and I are litigators. So I want to thank you for joining us today. We're going to have some time, a couple of hours to discuss things about immunity. If you're a novice to immunity, you'll get something out of this. If you are a litigator dealing with these immunity cases, we know you'll get something out of this because we're going to talk about immunity, but we're also going to discuss kind of how we do things at LoRusso Law Firm, how we help other firms use of force techniques, tactics, and legislation to change the rules.
Indeed.
So I am Lance LoRusso. I'm the founder of the Blue Line Lawyer Institute and the LoRusso Law Firm. I've been practicing law since 1999, licensed in Georgia, Tennessee, and Arkansas, and another state coming soon, hopefully. They have to accept me, so I question their judgment, but have an application in because we're trying to help folks as many states as we can. I have been a certified law enforcement officer since 1989. So we do a lot of work with public safety. We have two sides of the house. One side of the house is representing officers in catastrophic personal injury cases. We have about 6 wrongful death cases right now, tractor trailer wrecks, and all the terrible things that happen to law enforcement when they're out there driving on the streets. As I tell people, the average person drives about 12 to 13,000 miles a year if they drive a lot. Law enforcement officers can drive 50 and 60,000 miles a year just driving and patrolling the roads. The other side of the house, we take care of public safety. We stand up for public safety. And one area we're going to talk about today is legislation, going down to the State House, trying to get some bills passed and some legislation changed with the help of some awesome legislators who helped us out. And then on a daily basis, we handle everything from civil cases to immunity cases to proactive civil cases representing cops, defamation cases, deprivation of reputational immunity is another one that we've done. And obviously we respond to officer-involved shootings and critical incidents. I think to date, I'm at 178 critical incidents I respond to. What are you up to?
Oh, I don't know the exact number, but it's probably over 100 by now.
Yeah, so we're doing this on a regular basis, and it's all over the state of Georgia. It's an honor to be able to be there for our public safety folks when sometimes they are at their worst moment, having had to use force. All of our criminal cases that we handle have to do with use of force. People ask us to handle their DUI wrecks.
No,
we don't handle DUI cases. We've lost friends to DUI. It's great. If you're a criminal defense lawyer that does that, we support you and give us your information so we can send people to you because we don't do that work.
That's right.
So I'm going to let Ken introduce himself. Ken is our managing attorney, and Ken has been a friend for a long time, a lawyer extraordinaire, law enforcement officer of some renown. So I'm going to let you talk about yourself a little bit.
Well, thank you. So my name's Ken Davis. I'm the managing attorney here. I've been here since 2020. I started right in the middle of all the COVID things that happened. So it's been an interesting run.
Kind of in the office, then out of the office. Hey,
yes, indeed.
Go work from home.
That's exactly right. So I spent a career in law enforcement. I worked locally here for Cobb County Sheriff's Office. It's a large metropolitan county sheriff's office. I was there 29 years, and people ask me why I didn't stay 30. It's because I had something else to go do, and this was it.
And we're glad that you came with us.
It's been a great place to be. So during my tenure there, I did a lot of things. I like a lot of sheriff's offices. We run a jail, surprise. So I spent a lot of time working there. I was an assistant watch commander out there for a while. Wound up as the internal affairs commander for a number of years. Learned a lot there. And then my last duty post, I guess you would call it, was as the police academy director at our local law enforcement academy. I retired as a major. During all that, about 2012-ish, I decided to follow this guy and go to law school.
What were you
I'd always
thinking?
been, well,
Especially going at night.
I know. Yeah, I'd always had a lot of respect for what Lance has done, and thought that was something I really wanted to do. I was that nerdy guy in the agency that always enjoyed reading case law. I was kind of the search and seizure guy when I worked on investigations. I did that for a while, and it was kind of a natural fit. So went to law school, graduated in 2016, passed the bar in 2016, and finished out my time as the academy director. And then when I could retire, I took that opportunity and came here. And it's been a really great time here. Started out working, the kind of cases that you've already heard Lance talk about that we have. And then about a year or so into it, he asked me to be the managing attorney, which I have greatly enjoyed, and I appreciate the trust you put in me. So,
And one
it's
new
been
thing
good.
about your resume.
Yes.
I'm going to talk about an old thing on your resume and then a new thing on your resume. So part of my philosophy of always hiring people smarter than you, editor of your law review
I was.
and
Yes,
valedictorian.
I was. Thank you.
Yep. And then the newest one, grandpa.
Indeed. I
Yes.
have a 1-year-old grandson.
That is a title that Ken is very happy about. We're thinking of actually putting it on his name tag. What do you think? Ken
That's
Davis,
great.
managing attorney, your business card, grandpa.
Well, he had a onesie that said Papa's co-counsel. So,
Oh, yeah,
sorry,
clearly he
headed
is.
that way.
I like that. All right. So Ken is the new guy. Those of y'all that saw the first podcast, the first webinar we did with Blake Joyner, if you're the guest, and especially if you work for me and work with me, and I get to say, hey, I need you to do this, you get to read the disclaimer. Sorry. You know why you're reading it? Because I don't want to.
You don't want
That's
to.
why, but somebody has to. So here's the disclaimer.
All right. Here's the disclaimer. The information provided on this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials presented are for general informational purposes only. Any references to state law are for illustrative purposes only. You should contact a licensed attorney in your state to obtain advice with respect to any particular legal matter.
So you're saying that if somebody actually has a legal problem with real facts, they should go talk to a lawyer licensed in their state?
I know, shocking, but
That's
absolutely.
crazy talk.
Yes.
You should get ideas from us. We love when you get ideas from us. We will be putting out a paper. If you've signed on for the webinar, you will be able to get access to the show notes, if you will, which will give a lot of citations and probably some cases we may throw on there. And obviously, we want you to be a resource. But now we've satisfied our bar rules. Don't you feel better?
I feel a lot better.
All right. Well, now let's do a shameless FOP plug. All right. If you do not have the FOP legal defense plan, reach up, put your hand all the way up in the air, bend your arm down, and slap yourself in the back of the head. FOP legal defense plan.
Indeed.
FOPlegal.com. FOPlegal.com. And you'll find more information about that in our slides. All right. So Ken, history of immunity. Why immunity? There's been so much discussion about why anybody in law enforcement needs immunity. We've actually had somebody, I will call them, well, I won't call them a genius because they're not, but has gone around saying, ahead of a law enforcement organization, saying that law enforcement officers get away with murder because of qualified immunity. I mean, just so much vilification of this concept of immunity. So why don't you walk us through, why do we have immunity? I mean, why would any government agency, why would any law, why would any court grant anyone immunity, much less law enforcement?
Yeah, there's a lot of reasons, for that. One of the main reasons is the courts recognize people are human and they make mistakes, and nobody would do this job if there wasn't some allowance for that.
They don't do it for the money?
Job. Well, no, not really.
Yeah, if they do, we're going to send you for a fitness for duty because you can make a lot of money doing other stuff.
But immunity's got a really long history. We get this idea of immunity way before our country was founded. You get this idea of the divine right of kings. You couldn't see the king, and you couldn't go in his courts. And that idea carried over to our legal system here. We brought a lot of stuff over from England when we started our own legal system. So that's kind of where it come from. And this idea the sovereign shouldn't be held accountable in his own courts, it trickles down to folks who work for the sovereign, so to speak. And that's where that idea comes from. Although the reason is probably a little bit different now. Like I said, if there's no allowance for some error, if there's no margin of error, it'd be an impossible job to do. Any government job would be.
Yeah, and these are honest mistakes. These are not mistakes where somebody intentionally does something. So when someone says qualified immunity allows officers to get away with murder, if you commit the crime of murder, you can't get qualified immunity.
Yeah, that's exactly right.
Yeah. So and obviously, as we've talked about, the government can't act. If the government has a law it needs to enforce, or it needs to fix a road, or it needs to put a guardrail up, the legislature can say you need to have a guardrail on this roadway, but who has to build it?
Some DOT construction guy.
Some DOT construction guy has to go get a tractor out there and build it. And that's what we're talking about, people doing the business of the government.
Yeah, that's exactly right. Here in Georgia, it's been recognized since it was founded. And there's some statutory reason behind that too. So like in Georgia, under sovereign immunity, if you're going to sue the state, there's certain steps you got to take and certain things you got to go through. It's called the Georgia Tort Claims Act here, and it's in our code at 50-21-20. But basically, it says that suits against a public employee in their official capacity are barred, essentially. You know, that involves sovereign immunity. Now, that's on a state level. When you talk about federal level, it's a little bit different, right? So, you know, there's still sovereign immunity in the federal government, but in particular, you mentioned qualified immunity.
Mhm.
And so that comes up in 1983 defense. So I'm sure all of our attorneys are aware, probably most of our officers are aware. You know, there's a statute, it's 42 USC 1983, that allows folks to sue the government officials if there's a violation of their rights. It's been around a long time. This is not a new creation, and some people don't know that, but it's not. It originally came about, it's passed in 1871. A little history.
That was a long time ago.
Was a long time.
That was even
ago.
before I started policing.
It was
A little bit.
Really? Yeah.
Well, I don't know. You ask people in my office, they think I'm 100 years old, so it's close.
But and that bill is actually originally referred to, they call it the Ku Klux Klan bill, because it was aimed at, you know, folks who were hiding behind the Klan, basically to violate the rights of folks, you know, after and around Reconstruction.
So it was basically the whole history of this is to redress violations of constitutional rights. That's where this whole statute
Yeah, that's exactly right.
scheme came out of.
That's exactly right. So afterwards, though, it was dormant for nearly 100 years. It wasn't really used, and it wasn't used against law enforcement until 1961. You get this case that comes up, Monroe v. Pape in 1961, where the Chicago Police Department winds up getting sued, and they cite to 1983 for federal rights violations. And that's really the first time it gets applied to the police. In that particular case, they said, hey, you know, the Chicago Police Department is not a person, because if you read 1983, it's referred to a person. But then a few years later, you had another case, Monell versus
Monell liability.
Yeah. And it then held that municipalities could be held liable under 1983. But it looked at it as far as what their policy and custom is.
Right.
There's
So
not,
basically you could treat them as a person under the statute.
yeah, and there's no vicarious liability. You can't sue them just because of what one of their employees did. It's got to be related to their policies, to their procedures, to some customer practice that they're engaged in, or it could have been something that's decided by you know, the main person, right? The person who
The
makes
decision maker.
the decision maker.
Yeah, and
the decision maker.
it's really interesting. You mentioned that this has been around a long time. This is not something somebody found in a coffee shop yesterday while they were
No.
on their computer. And unfortunately, we hear people come up with this, and you know, stuff sounds really good inside their head, but not so much out here.
That's right.
And you know, their moms are proud of them, but really nobody else is. And one of the issues that is overriding a lot of this 1983 litigation, whether it's under Monell liability for a city or if it's an individual, you have to show a constitutional violation.
That's right.
You can't just say somebody ran into me with the side of their car. And I think that's where a lot of this tension is. We're going to talk about a case out of the Third Circuit. What is the constitutional violation? And I think sometimes you and I have seen this teaching people. Well, people say, well, we'll get sued. We'll get sued for what? We'll get sued for violating someone's constitutional rights. And the Blue Line Lawyer Institute and these webinars are all about ask the question, which constitutional right is at issue? And I say that for the law enforcement officers who are trainers, for the administrators, for the police command staff. Don't just be afraid of liability. You have to dig deeper to say, what is the constitutional right we're trying to protect? Because we're supposed to protect people's constitutional rights. If we don't, that leads to liability. But it's too easy to say, well, we're going to get sued.
That's right. And that is something, if you have folks in a position of authority that don't understand this, it can really be debilitating to them being able to serve their function and serve the people that they're there to serve.
Yeah, and sometimes we see people writing policies and we read the policy and it's like, why did you write this policy? Because we don't want to get sued. Well, first of all, the policy is not going to stop you from getting sued. No policy has ever stopped you from getting sued. The suit can be filed. It may be a defense, but the policies are guidelines. The policies have to govern all those individuals you were talking about who have to make those decisions. See, try this language offside. See if you like it.
Yeah.
who are making split-second decisions under circumstances that are tense, uncertain, and rapidly evolving. Isn't that eloquent?
Man, that's pretty good. You ought to write that down somewhere.
Stolen from Graham versus Connor.
Indeed.
But it really talks about the fact that it's the people on the ground, the people instituting government decisions, making decisions to enforce government policy. And really, that's what laws are. They are government policies.
Indeed. Indeed. So kind of the other step, I guess, from this is this idea of qualified immunity, because we've talked a lot about what 1983 is. So the government and the courts, I should say, recognize, as we talked about earlier, that there needs to be some mechanism to protect government employees when they're making these important decisions. So qualified immunity has been such a hot topic over the last couple of years. You mentioned that quote that you heard. And it's just not right. It just doesn't describe what it actually is and what it's for.
Yeah, and the amazing thing to me about this qualified immunity that we hear a lot, and immunity in general, is are law enforcement officers the only ones to have immunity?
Absolutely not.
And it's really hilarious when people say we need to do away with immunity. It's like, okay, let's start with legislators. Whoa, 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 whoa.
Right.
We're not going to do that. Well, let's start with judges. Hang on. Well, legislators and judges have what kind of immunity?
They have absolute immunity.
They have absolute immunity.
Yeah.
There's nothing qualified about it.
That's right.
So lots of government officials, again, who are doing the work of the government, instituting the policy, have immunity. So tell us a little bit about how some of this came around and how some of the, again, I mentioned Graham versus Connor, but
sure,
how did we get to where we are?
So when you talk about qualified immunity, it is court created. That's one of the criticisms of it sometimes. Mm-hmm. It's not found in the text of 1983. But really the first place we see this, it's a 1967 case. It's called Pearson v. Reyes, Pierson, for those of you taking notes at home. And in that case, they discuss qualified immunity. And there's a great quote out of that I want to read because it's just too good not to. It says, "A policeman's lot is not so unhappy that he must choose between being charged with the dereliction of duty if he does not arrest when he has probable cause, and being mulcated," never heard that word already here, in damages if he does. The court's recognizing, hey, you've got a person, and this one's specifically dealing with police, in a position where they have to make a decision. We don't want their decisions hamstrung because they're thinking of what the possible outcome is going to be. I mean, that can be detrimental to the public generally, but it can be downright deadly. Yeah,
and it's really interesting. For the past, I guess, probably 15 years, we've had this big debate about the stand your ground laws. And I remember when law enforcement officers were up in arms about the stand your ground laws, and my answer, I have two words for them, not those two. Shut up.
Yeah.
Because the bottom line is law enforcement has to stand their ground every day. Could you imagine picking up the phone and calling police, say, hey, there's this dangerous guy. He's trying to break into my house. The police go up and go, yeah, it looks like that might be dangerous. We're in service.
That's right.
I mean, that's not what they do. And, we have real issues. You being the commander of an internal affairs unit, dereliction of duty is something that we look at. You have an obligation to move forward. And the example that I always try to give you pieces you can use when you're having conversations, whether they're in the boardroom, whether they're with your elected officials, or whether they're at cocktail parties, because sometimes all of those are important, depending on who's at the cocktail party. This concept of officers not moving forward. Mm-hmm. Do we want a society, do we want situations where officers step up to a school building and say there's too much liability when I hear gunshots, I'm going to walk away?
That's right.
And I use the school building because right now so many people are concerned, and rightly so, and focused on these active assailants. So that's the exact situation, and it's no different than the officer who stops a car at 3 a.m. because they made a decision. Should I stop the car? Should I get the driver out? Do I smell marijuana? Do I smell an odor of alcoholic beverage? Does the driver look impaired? And as you said, they can make mistakes.
That's right.
They can be wrong. And if they're wrong and they're doing the right thing, making discretionary decisions, right? Then they should be entitled to we're in the South, so I guess we would say some grace.
Some grace.
How's that? What type of decisions also do law enforcement officers make that they can't apply for qualified immunity?
So to touch on something just a second, is you mentioned the fact that they might make mistakes, and that they might be reasonable but wrong, and that kind of invokes the language from Graham. But it's mm-hmm. true. You can have a reasonable belief that is entirely wrong. And I think that's an important thing to remember. So when you talk about discretion, then the other thing which doesn't get you any kind of immunity is if you're involved in a ministerial act, and that's something you have to do.
That sounds like a big word.
Yeah, I had to look it up.
Well, I'll tell you, my easy way that I remember ministerial is it begins with an M. You must do it.
That's right.
You don't have a choice.
Right.
So working in the jail, what's one of the ministerial acts that we know? We use it all the time, but it's unquestionable you have to do it.
Well, you have to keep them from escaping. That's
Yes.
one ministerial act.
And you also have to make sure they get a medical
That's right.
evaluation. You have to make sure that you get their information before you let them out. I mean, qualification, the Farmer versus Brennan, making sure you're qualifying people. You're not putting folks in a pod where they're going to be in danger. Those are must do's. Rendering aid, all of those things, those are must do's. But very few actions by public officials, not just by law enforcement, are ministerial. Most of them are discretionary.
That's right. And use of force is always discretionary.
Very true. The whether to use force and how much force to use.
That's right.
Is always discretionary.
That's right. So in looking at qualified immunity, so the Supreme Court came up with this in the case we just talked about. So then how are they going to decide this? So really there's two prongs to it, right? It's whether or not there's a constitutional violation, and then whether or not the government official acted in opposition to some well-established law. So both of those things have to be looked at. One of the cases that I'm sure most of the folks out there are familiar with, at least the attorneys, Saucier v. Katz. Supreme Court in that case looked at qualified immunity and said, you've got to determine both of these things, right? Well, that didn't hold up. So you get another case, Pearson v. Callahan. It's a 2009 case, and the court says, you don't have to determine both of those things necessarily. And what we see a lot of times today is you'll see a court actually looking to see, is there some violation of well-established law? And if there's not, then they may not get to whether or not there's a constitutional violation.
Right. And that's the controversy. Some people say they should decide whether there's a violation of a constitutional principle first, as opposed to, was there a clearly established law on the issue? So, and the circuits are split on that a little bit, but that's something we've wrestled with as we read these cases. We're in the 11th Circuit, and you have other circuits that handle them differently. And that's kind of the yin and the yang of these, right? Everybody's always arguing about which one to look at first.
And, and the question arises, what is well-established law? Where does it come from? And so you've really got to pay attention to your jurisdiction, because things that may have been held, we're in the 11th Circuit here. So let's say you're in the 10th Circuit, which is one of the cases we'll talk about later. The law that's well established there may not be law that's well established here.
Right. And that's one. And by the way, we had an expert witness recently in court who was sitting in the 11th Circuit and didn't know what the 11th Circuit was. Riveting expert.
Yes, riveting.
It was actually kind of fun, but it's because I was cross-examining. It was a lot of fun. But if you don't know what federal circuit you are in, take the other hand, reach it over your head, bend your, and I mean, you have to. If you're a government employee, you have to know what federal circuit you're in. Obviously, Supreme Court precedent is going to govern everybody. Right. But remember, Supreme Court precedent sometimes will say, we're trying to solve a dispute among the circuits. So for the folks that are not lawyers, when you hear that, that should tune your ear as a law enforcement trainer or an executive, that they're trying to resolve a battle of the circuits as to how something goes on. Mm-hmm. But until that court rules, and sometimes they don't rule.
That's right.
Supreme Court doesn't take hundreds of cases that are brought to them. So you have to know what's going on in your jurisdiction. And then you also, remember, we have state constitutional issues too. So make sure you're looking at your state Supreme Court, and your state Supreme Court is extremely important unless you're in New York. Because then the highest court is the Court of Appeals, which I always loved. I always thought that was cool.
Yeah. It's you're exactly right. And to touch on the state issue, those things probably go under the radar a little more than others. But most of your state officials, and we've got some discussion of criminal immunity later, I think. We're going to talk about that a little bit.
We are going to talk.
Criminal law is primarily an animal of the state, not entirely, of course, because there is federal criminal law, but for the most part, most criminal law that gets enforced is an animal of the state. But anyhow, you get this case where the court says, nope, you don't have to determine these two things separately. But then kind of the other thing that the court has said as far as established law is it's got to be established with some level of particularity. It's got to be close in the facts. It doesn't have to be identical. But it's got to be pretty close. And that's where the courts seem to miss it sometimes, the appellate courts. there's been a number of times, and that is a couple of cases we're going to talk about, but where they generalize facts. For instance, a case is White v. Poly.
I love White v. Poly.
I'm not
Great case. Scary facts, by the way. Anybody
Yeah.
who's in patrol, if you read White v. Poly, it's out of the 10th Circuit, went to the Supreme Court. Scary facts.
Yeah, and in that particular case, they looked to Tennessee v. Garner, and of course, I know my law enforcement folks know Tennessee v. Garner, and the attorneys do too. And one of the things that's in Tennessee v. Garner, it's not talked about a lot, but there is a statement in Tennessee v. Garner that encourages, if you're going to shoot, to give a warning if you can. And that's really what the plaintiff in that case was kind of hanging their hat on. And the court said, no, that's not particularized enough to these facts. You can't say that applies here. That's because they were saying that, because in that case, the officer didn't give a warning. A lot of other facts with that that we won't discuss. But
well, 1985, a lot has changed since 1985.
Indeed. But he didn't give a warning, and they tried to say, well, that's in violation of established law, and they point to Tennessee v. Garner, and the court said that's not particularized to this at all. That's from they call a high level of generalization. So
now, interesting thing about Garner too that I really love about this case. So we said 1985, 4 years before Graham versus Connor, which is kind of the big case about qualified immunity. But the thing about Tennessee versus Garner that a lot of people forget, the officers received qualified immunity.
Yes.
But that set the precedent. Going forward, you won't if you do X, Y, Z. So a lot of times when you look at these cases, don't just look for whether the officer won or lost. Okay.
Mhm.
And if you're trainers, we all want to win, right? There's lessons in winning and there's lessons in losing. And I've had people ask me this question before. It's like, I've read this case 14 times. Why is it important? Our county attorney sent this to us. Why am I supposed to do an in-service on this? It's because the lesson in the case, the officer may have been okay, but it may have changed the way you can police going forward. It can change your obligations. It can change what has to go into the mix. And as you said, it may change what is now objectively reasonable moving forward.
That's right. Yeah. And Tennessee v. Garner had far-reaching effects in that regard. And in fact, one of the statutes that I know you're going to mention later in Georgia, 17-420, it talks about use of force by a law enforcement officer to effect an arrest. It drastically changed after Tennessee v. Garner because Georgia, like many other states at the time, had laws that said you could use deadly force to apprehend a felon, period. And of course, that got reversed and state law changed.
So I think we're back on. So one of the things about Graham versus Connor, and I call it teenage angst because some of these folks that are criticizing it acting like teenagers. Yeah. Graham versus Connor said that whenever a law enforcement officer uses force, we're going to use a reasonableness standard under the Fourth Amendment.
That's right.
Prior to that, it was kind of split, whether it was deadly force or non-deadly force.
That's right.
So, Graham versus Connor, 1989, people have screamed and hollered about it, and it needs to go away. I'm convinced the vast majority of people who say it needs to go away have never read it.
I agree with you completely.
And one of the things that it took away in there was a complete subjective standard. It said objective reasonableness. So the officers' reasonable beliefs about why they used force had to be examined from a standard of objective reasonableness.
Right. Yeah. And one of the really important things about Graham is, it did change the standard. You get Tennessee v. Garner that changes the standard for deadly force to this reasonableness standard. And then you get Graham, 4 years later that changes it for all use of force. But what was it before that? And it was a case, Johnson v. Glick, and it was for our attorney folks out there, it was based in a substantive due process. Say that 5 times fast.
I'd rather not, actually, if it's okay with you.
And it went forward from a premise that there's this generalized right to be free from excessive force. And in Garner and eventually in Graham, the court said no. There's a simple, specific thing in the Constitution called the Fourth Amendment that we can look to without having to do that. But some of the requirements under the old standard, is you had to determine if there was a need for force. But one of them was also proportionality of the force. Was the force proportional or not? And we're starting to see a return to that in some places, or at least that idea.
Right. And
that's problematic. It's problematic because how can you determine what's proportional? And the Graham court looked at that and said, whether it's reasonable or not, it's what matters.
Right, because the proportionality doesn't work. It's amorphous. And one of the ways we're seeing a return to that is a subject shooting at an officer. and the officer shoots back. To quote a famous sheriff we like to quote, they shoot back a lot.
Yeah.
And, you know, the recognition, and we see this in a case called Plumhoff versus Ricard, officers are taught to shoot until the threat has stopped. And in Graham versus Connor, they were basically saying, look, it's the reasonableness of the officer using force at the time, not you counting bullets that they used. And what we see in this tension in the law, and tension's good in the law, okay? We like tension. If you've never read Sandra Day O'Connor's book, The Majesty of the Law, I highly recommend it. It talks about how the law is made and why tension is good. Legal arguments are good, and actually having healthy, friendly disagreements with people is a good thing for the law.
Right.
But this notion that, okay, well, yes, the officer was having a gun pointed at them. Yes, the officer needed to use force. But in the end analysis, they used too many bullets to lawfully stop the threat is not only craziness, it's contrary to the law, it's contrary to the reality of use of force, but it also leads into this loop that takes us backwards from arguments that the Supreme Court specifically rejected.
That's right. And they did reject those. And, you know, another thing that came out of that Graham took out of the equation that was present in the Glick standard is what the intent of the officer was. And what the court said is basically, you know, with the reasonableness standard, force is either reasonable or not, regardless of the intent of the officer. So, yeah, and how many bullets? How many bullets is too many? If you're standing there on the scene and you're the one whose life is being threatened, or you're trying to protect somebody else's life is being threatened, how are you supposed to know that then? There's no way.
Yeah, and I think the other thing that was really interesting about taking the intent of the officer out of the mix, if people really read Graham, and even if they don't like the police, can you believe people don't like the police?
I've heard that.
There's a few.
Yeah.
If they don't like police, then they should love that, because as the court says in Graham, a good motive will not change unreasonable force to reasonable.
That's right.
Just like a bad motive will not change reasonable force into something that's actionable. And I think that's so critical right now, where we have folks using AI bots to scan law enforcement officers' social media to say, well, yeah, he's a good cop, but he said something that's bad right here, so they need to leave the profession. So, you know, if you're a police administrator, if you're a law enforcement agency, if you're dealing with these issues, you know, you can cite to this. And the other thing you can cite to is this lack of hindsight that came out of Graham. So we're not going to look at the officers' actions in 2020 hindsight from the safety of the judge's chambers. And what I like to point out about, I was sworn into the U.S. Supreme Court several years ago. Fantastic. As far as I know, it's the last building in Washington built under budget. They actually returned some money to the federal budget. Yeah, it is probably $15. No, but they did. They returned money, and that was probably a long time ago.
Yes.
But you go through metal detectors to walk in the front door of the Supreme Court. You go through metal detectors to walk around the building. And you go through metal detectors and get wanted to go into the chambers of the court itself to hear argument. Now, when you're talking about the judge's chambers, I can't imagine the levels of security. So when a judge writes, we should not judge the officer's use of force from the safety of the judge's chambers, or say what may seem reasonable on the street may be reasonable on the street, but may not seem palatable, if you will, or politically correct, if you will, in the judge's chambers. We need to pay attention to that. They knew what they were talking about. This is a very, very well thought out, very reasoned, and as you said, from 1926, a lot of chewing on a lot of case law by a lot of different judges. This was not one rogue Supreme Court justice who decided to write this opinion.
No, not at all. And it's, you know, it's so well written, and it contemplates those sorts of things. And the idea of hindsight, you know, when I hear that, one of the things that I think about is the prevalence now of body camera video. And that was so demanded and so pushed forward. But in some ways, it can invite, to those who aren't paying attention, it can invite a hindsight analysis, because they can look at this video and say, well, if I'd have been there, I'd have done this, or if I'd have been there, I'd have done something differently.
Yeah. And with most citizens, you'd say, well, if you were there, you wouldn't be there because you would have left.
That's right. And as you have often said, no use of force looks good on video, period.
Oh, it never will.
So that, to me, that engenders that.
You know what looks really good on video?
What's that?
Compliance with an officer's lawful commands. Doesn't that
Yes,
look good?
it does.
You
look
ever
good.
seen that on video?
Well, it doesn't really get played when it happens.
Yeah, yeah.
No
We
issue.
see it on video all the time.
Yeah.
It looks good.
Yeah. So I was going to talk about these cases just a
Yeah,
minute.
two
So,
really important cases, 2021 at the Supreme Court. And keep in mind, as Ken's pulling up his notes here, you've got this tension and all these people screaming and hollering. And I helped out some folks in Illinois when they were dealing with some issues with qualified immunity. I was very honored that they asked me to do that. And I had a question from a politician, and he was an elected official, and he said, you know, my constituents want something done about qualified immunity. I said, sir, your constituents want a quick response and decisive action when they're in trouble and they need help.
that's right.
And if you do away with qualified immunity, you will have neither one. All right. So in the middle of this, we have two cases in 2021, and with a nod to the Supreme Court, because we're members of the bar.
Yeah.
So with all due deference to the Supreme Court, can you please pick two cases that are easier to pronounce?
I totally agree.
Did they, you know, they have all these cert petitions. Do they fish through there and go, people will be talking about this one for 30 years and no one can say it?
That's right. At least Graham was easy to say.
Graham's very easy to say. I can even say Connor.
I think I can, yeah. So Tahlequah versus Bond, this actually happened out in Oklahoma. So this was I believe it was a 10th Circuit case. Yeah. And in this case, the facts are pretty straightforward and somewhat heinous. So you have a lady, she is the ex-wife of a gentleman who decided to come to her house. He doesn't live there anymore. She wanted him to leave. She calls 911. The police come out, they engage him in some conversation. She had told the officers that there's tools in the basement. They wind up talking to him in the basement. They start talking about that he might go to jail, something along those lines. So he goes to his tool bench, picks up a hammer, and approaches both officers with a hammer in his hands over his head, and they shoot. So there's a civil case that comes up. The 10th Circuit hears this case and dismisses it based on qualified immunity. I'm sorry, the district court did. Then it's appealed. The 10th Circuit appellate court reversed it, and they reversed it based on another case that they felt was well-established law. And when it gets to the U.S. Supreme Court, again, this is another one of those cases where they look at it and say, no, these facts are not particularized enough to what you say the well-established law is. So then they grant them qualified immunity. And it just reiterates this idea of how important it is to understand well-established law. And this seems to kind of be a theme where the District Court of Appeals wind up applying the law in a way that's not particularized, and then the court overturns it. It's what happened at White, what happened here. It's actually what happened in the next case we'll discuss too.
And that's, as we talked about, this tension in the law. Do we look at what constitutional right was violated? Do we look at whether it was clearly established first? And, the other thing about this case, which was very interesting, this is where we had 3 points come up. Number one was, well, why didn't the officers just step away?
That's right.
Well, now we're in the dereliction of duty things. There's somebody at the house who's not supposed to be there. We've all seen horrible effects of domestic violence. We've also seen horrible effects of when somebody manifests an intent to cause an injury to someone. Law enforcement can't just walk away. The second one is that, and that's kind of the 2020 hindsight thing. Well, looking back on it, well, yeah, if you weren't there, he wouldn't have done anything. The second thing was this officer created jeopardy. They said, well, if the officers hadn't gone down to the basement, then this wouldn't have happened. Officer created jeopardy has been abrogated by the United States Supreme Court in LA County versus Mendez. Plus, it's just dumb. The officers don't have a choice but to be there. So the 2020 hindsight we see invading, well, if the officer used better tactics, the subject, and we actually have a couple criminal cases where somebody have done this to our clients, if they used better tactics, or one, if they were more polite, they would not have been attacked by the subject. Therefore, their use of force is unlawful. I'm going to walk y'all through that again because it sounds crazy, but that's where officer-created jeopardy is being used by prosecutors, as we've seen, and in some cases, suing officers. The argument, we don't agree with this. The argument is if the officer used better tactics in the moment, the subject would not have had an opportunity to assault them. Therefore, the officer's lawful use of force becomes unlawful, because they could have prevented it in the past. And there's a really easy way to look at this. Just try this on. You're sitting down.
Yes, I'm sitting down.
How about don't assault police? Is that kind of,
well.
that would work really
That
well.
would work really well.
Yeah. So I think that was a big issue that happened in that case. And then the other thing I think that got lost in that case, and a shameless plug for my folks over there at Force Science, because they are amazing about this.
Yes, they are.
The reality of that use of force context, and that's what we're going to talk about in the second hour, is about this context of the law enforcement action and what it takes and how fast. There were several people kind of getting to that intent of the officer. Well, he just had a hammer. Why'd they have to shoot him? He just had a hammer. Or he's across the room and he had a hammer. So this reality of how fast these situations occur and how deadly a common object can be. And in looking at these, for those, because we have a mix, we have lawyers from all over the United States, which we're very honored. I think we have people from 15 or 16 states that have signed on. It's fantastic. And then we have trainers, we have police administrators. When you see statistics of officers shooting unarmed people, we've discovered that unarmed means no gun.
That's right.
So famously, we had, and it hit home for some us in Georgia. Famously, there was somebody who was listed as being unarmed in a 2015 survey, and he was swinging a shovel at a law enforcement officer. If you swing farm implements at me, I'm going to shoot you.
Absolutely.
And the question is, can that shovel, does it have the potential to cause serious bodily injury or death? Well, here in Tahlequah, the Tahlequah case, we got a hammer.
That's right.
I mean, I tell people a golf club can be deadly. Even my golf swing will hurt somebody. I mean, you can't hit somebody in the head with a hammer without causing a serious bodily injury. So the speed of that interaction, there's three really, really good points to take out of the Tahlequah case.
Yeah. And to me, that's really related to this same idea of proportionality, just a little bit differently.
Absolutely.
So, you know, is it proportional to force? Well, how are you going to know? How are you going to know that your actions, as far as what you were saying with people that think, preclusion or however you want to phrase that, how do you know ahead of time how your actions are going to drive that? And you can't.
Or the effect. And we've
Or the
certainly seen, and everybody here has seen videos, and you can watch them on YouTube, where someone is shot and they're hit. And that has no effect whatsoever. And that's even subjectively looking at the video afterwards. Now, imagine if you're the officer in the moment, you shot, it has no effect. What would you reasonably conclude?
Either didn't hit them or
it didn't hit them or it didn't hit a vital area. So that's where we have these multiple shots and people say, well, why'd you have to shoot him 12 times? I didn't have to.
Right.
I felt in the moment that I had to stop the threat. So
that's exactly right. And the purpose of the shooting is to stop the threat. And until it stops, you're perfectly justified in that. So the other case, also another 2021 case, you could say same song, different verse, because it's very similar. It's Rivas Villegas. There's another one of those.
Villegas. Yeah.
Villegas versus Corsaluna. So 2021 Supreme Court case. Interestingly, so I think it's interesting because of the timing of it too. So it came out of the Ninth Circuit. Again, the district court granted qualified immunity. The Ninth Circuit Court of Appeals reversed that, and then it wound up going to the Supreme Court, who then reversed the Ninth Circuit. Same idea. They said that the court, that the appeals court was looking at this from too high a level of generality, and it wasn't particular enough to the case they were quoting. The reason I think the timing is interesting, because this case involves a subject that they were arresting. They were asking him to come out of a house. He'd been threatening a lady that was in the house. He comes out. One of the officers sees that he has a knife in his pocket. So when they see he has a knife in his pocket, they actually wind up using a couple of beanbag rounds and stunning. They give him commands. He eventually gets down. So when they go up to take control of him, one of the officers puts his knee in his back near where the knife was. And I think it was only for a total of a number of seconds. I forget the exact
number of seconds.
It wasn't long. 8 seconds, I believe, is what the decision says. And they sued over that. And they said that was in violation of well-established law. This is, within a year of George Floyd, and I guess the kneeling, and that probably had a lot to do with it. And the court looked at the cases that they cited. The case that they were saying it was similar to was a much more heinous case. that wasn't just trying to control a subject like this one was. And the Supreme Court, just like they said in the other cases, so that is not similar enough. That is not well-established law. If they were saying it was well-established law, you couldn't do that. And the Supreme Court said no.
Yeah, and this White versus Pauley case, if you haven't read it, I think is very, very important to realize that there's lessons in these cases, but don't go crazy. You know, consult an attorney in your area, consult your FOP lawyer. You know what? FOP plug.
Yeah.
Consult your FOP lawyer, the person who's actually going to show up on the scene of your shooting. Some of these cases take years to get to the courts and to get a resolution, good or bad. And it's very, very difficult to kind of have that hanging over your head. But it's really difficult to defend it by yourself.
Indeed. Indeed. And FOP will help you do that.
Yes. Now, we talk about immunity. We're talking about civil immunity and criminal immunity, but I think you have some more stuff on immunity for us.
Yeah, just a little bit more in the civil realm. So that's the federal angle, right? So there's also state law. There's state law where there's immunity for the states individually. I mentioned earlier sovereign immunity. It's based in state law. In Georgia, as I mentioned, we have the Georgia Torts Claim Act, and basically in Georgia, a public official can be liable only for ministerial acts. Remember, we talked about that, something they have to do, that are negligently performed, or acts that are performed with malice, with some intent to injure. And we've already defined what those two things are. But again, discretionary use of force is always discretionary.
Yeah, and one of the things that I really love about the Georgia statute, and if you have it there, if you can just kind of tell people what it is, but the thing I love about the Georgia statute is the statute and the case law, and we can put it in the show notes if you don't have it, but or it looks like you have it.
I have one.
So it says that a public official, the purpose of immunity is so a public official will not have to bear the burden of a civil suit. And this all loops back in. Now, yeah, you can get on your social media page and be the keyboard warrior and say they shouldn't even bear the burden. This is crazy. But it's not the officer making the decision to stop the car to enforce the red light violation. Right. Someone in the legislature has decided, no, we don't do this in Georgia, but you shouldn't run red lights. I mean, in Georgia, when a light turns red, you got like 4 or 5 cars that can go through before it's supposed to go kind of orange. Right? Yeah, I think it goes actually from yellow to orange and then it turns red. But, somebody has made that decision. So that officer took an oath to enforce the law. Are they going to turn their back on criminal behavior? Are they going to turn their back on requests for service? Or are they going to make those decisions in the moment, even though they may have incomplete information? They may be lied to. They may have bad information from the 911 center because it was translated badly. So that statute really has some great case law, great language in it.
It does, and that that particular statute is actually not the one I have in front of me. I have another one, but it kind of harkens back to this whole idea of what immunity is in the first place. It is a generalized. It's not you didn't do it. That's not it. It's not the defense I didn't do it. It is there was a reason, and because of that, I shouldn't be held responsible for it for whatever reason, because I followed the law. That's a really good reason not to be held responsible.
Or your training.
Or your training.
Yeah, and there's another thing that I tell people I teach at Columbus State University in the Command College, and I'm honored to do that. And I ask people to say, okay, we're going to take 5 people in the room, and I'm going to give each one of you $100,000, and we're going to meet next week, and I want you to come up with an idea for a business where we'll all make a lot of money. And if you show up and your idea is to start a police department, we're going to take your money and throw you out, because nobody in their right mind would do that. And as much as, we talk about private ventures and making money, that's what drives our economy. These law enforcement functions, just like DOT functions, just like sewer and water functions, no one wants to do them. No. So they fall to the government. And when governments institute those actions, they have to do it through people.
Yeah. So the statute I was going to mention, though, it is statutory civil immunity, but it's particular to use of force. So it's 5111(9) in the Georgia Code. It says a person is justified in threatening or using force against another under the provisions of Code Section 16321, which I think you're going to talk about.
We're going to talk about that.
Relating to the use of force in defense of self or others, Code Section 16323, relating to the use of force in defense of habitation, Code Section 16324, relating to the use of force in defense of property other than a habitation, has no duty to retreat from the use of such force, and shall not be held liable to the person against whom the use of force was justified to any person acting as an accomplice or assistance. This is kind of Georgia's version of stand your ground too.
Right. And we're going to go ahead and provide this. And there's a couple of other laws that Georgia kind of folded together for the whole stand your ground concept, which was for private citizens, not for law enforcement. But law enforcement officers are citizens too, aren't they?
I've heard that.
Yeah, I've heard that. But you know, it's an interesting thing about it, and we're going to upload some of these statutes so you can see them. For the people that are out of state, if we upload a Georgia statute, look in your state, look for a parallel, or as we're going to talk about second hour, go to the legislature and change the law.
That's right.
All right. So you had some other things on immunity, I think specifically about criminal immunity.
So yeah, so when it comes to criminal immunity, again, criminal law is typically an animal of the state. But one interesting exception that we kind of wanted to talk about, and we've had some experience with it, is this idea of supremacy clause immunity. So what happens at the intersection of what state law says versus what federal law says. And that's really where we get this idea of supremacy clause immunity. You've got a clause in the Constitution that says it's the law of the land, it's supreme to all other laws, but yet you may have a state that takes someone who's acting under federal authority and then they want to criminally prosecute them for some violation of state law. And
so we're talking about federal agents.
We are, and we've had that very issue arise. So
we are working with a very high profile case right now, and then we have other cases we've been consulted on. But this concept, and the thing I love about this case law surrounding supremacy clause immunity, not a lot of cases, you can probably read them all in one afternoon. Right. But what I love about it is the language of the Supreme Court, the language of the circuits saying the reason we have supremacy clause immunity is not because we don't respect the right of the state to prosecute their criminal laws, but when the federal government acts, it has to do so through individuals. And if the individual federal agent, federal officer, and there's one limited exception, if they're working on behalf of or in conjunction with a federal officer, if they're doing the business of the federal government, then they should be immune under supremacy clause immunity from state prosecution.
Absolutely. And that is what it says. You know, a federal employee who's charged with a state crime based on conduct that was part of their official duties, then the Constitution protects them from that prosecution. We see this developed by the Supreme Court in a case, for those of you who want to go take a look at it, it's In re Nagel, 135 U.S. 1. It's a 1980 case. It's kind of
1890. 1890 case. And I can tell y'all one of the most fun things is standing in front of a court and citing a case that is over 100 years old.
Yeah.
That's actually really cool. The only people I know that get to do that are people I went to law school with who represent railroads. They routinely cite cases from the 1830s.
I imagine a lot of railroad law would be.
A lot of railroad
law. But it says that federal officers should be immune for prosecution for acts that they did while they were in the scope of their duties. There's actually a two-part test that it puts forward. One of the questions they ask is, was the officer performing an act that federal law authorized them to perform?
Which makes sense based on what we said. So, and it's interesting when we look at this whole evolution of qualified immunity, a much maligned qualified immunity. Maybe we'll have a class on a webinar on the much maligned blue line flag, but that's a whole other story. But the issue of supremacy clause immunity is the first thing you have to prove is you were doing what the government wanted you to do, and you were performing an act of the government. And we don't see this as clearly expressed in other cases, but you can lean on, and for the lawyers here, you can lean on that language from the Supreme Court and In re Nagel to say this is the basis of even extending immunity to anybody. You have to be doing something on behalf of the government.
That's right. And that even harkens back to qualified immunity. You know, qualified immunity applies when you're acting in your governmental capacity. So the second prong of that is, were the actions necessary and proper to fulfilling that duty?
So a little different than we heard in the qualified immunity analysis, but kind of the same. What did the individual on the ground, the boots on the ground, what did they physically do?
Yeah, exactly. So if you satisfy that test, then you are eligible to claim supremacy clause immunity. So how do you get there? Well, if you for the attorneys out there, if you have a case that's charged under state law, you have a federal official that's charged in that case, and you want to remove it, you can. It's under 28 U.S.C. 1442.
Now, hang on a minute. That's the removal for civil cases, right?
It's removal for a lot of things. Yeah,
that's exactly what I had from a prosecutor when I filed one that said, that's for civil cases. Okay, I know that's what they told you in civil procedure when you took it in law school.
Yeah.
It actually talks about criminal cases too.
It does. It's in the statute particularly. So You know, there's a procedure for it too that's in 1455. And you have to remove it in a very narrow time frame. You got to remove it
within 30 days of the arraignment.
Yeah, it's very quick. It's a very fast
Yeah,
turnaround.
it is a quick turnaround, and some states vary on when they do arraignments. So sometimes it has to be within 30 days of an indictment, sometimes it has to be within a different time frame. But you know, the other issue, kind of getting this supremacy clause immunity down to the actual function of the officer and the objective reasonableness, and this is the nerdy stuff that you and I sit and talk about in your office. If you will, the corollary to objective reasonableness in the supremacy clause immunity is this notion that the officer did no more than was reasonably necessary to perform their job. Right. So this notion, and at some point somebody may see this who's not supportive of law enforcement, this notion that officers don't have to prove anything is ridiculous. It is. You know, several years ago, the Fraternal Order Police did a study of federal circuits and how often officers receive qualified immunity. 100%. Shocking.
That is shocking.
It was about 52%, and they studied hundreds of cases. So, you know, this notion and this misunderstanding of immunity to start with is just absolutely crazy. And the first thing that I always remind people, because I want to, again, give you all an opportunity to debate, when you're having a conversation with your city manager or your city attorney or your judge, they have immunity too. And if you start taking it away from law enforcement officers, who, by the way, have to make a lot more of those split-second decisions, you know, the judges, this is the example that I give, judges rarely have to make split-second decisions. Right. And a judge can use those terms that litigators hate. I'm taking it under advisement. It's like, rule, come on. So if they can take it under advisement, they can wait, they can study the law, they can talk to other judges, they can get it researched. They have absolute immunity. Yeah. And that's a policy decision, because we know we want someone making those decisions. You know, we need to have a judge up there calling balls and strikes in criminal trials.
Yeah, and how backwards would a system be that gives a judge who has really infinite time to make a decision absolute immunity, and then taking a government official who's actually on the front lines making split-second decisions without the benefit of that time, and saying that they can have no immunity? Absolutely. It's a ridiculous concept.
Right, and there is a parallel between our judge and our officer on the street. Neither one of them get to choose which facts are before them.
That's right.
You know, and it's really even more difficult when you sit and think about the fact that the court has the opportunity to separate the wheat from the chaff. And that's what the rules of evidence are about. We're going to get to the truth. We're going to get to the facts, as opposed to the officer who shows up on the scene and they got something they were told by 911. They read something on an NDT. They're driving up on the scene. They see something that may represent to be X and it's actually Y, and they get people that are telling them information, all these different sources. So it's almost, to me, that immunity, and again, this kind of gets into our next section, just talking, and we'll kind of move into it just a little bit, but gets into our notion about why immunity exists. We recognize that law enforcement officers are going to make decisions. I'm going to try this on. You tell me if I'm out of line here. We know that officers are going to make decisions with incomplete information.
They have to.
Yeah. Now, you were a detective for a long time. I would call myself more of a defective, but I did work in plainclothes for a while. It's an example of the detective sitting there looking and trying to decide if there's probable cause to go take a warrant for someone. Now, that's one step away from the street. So we'd say, well, they have all the time in the world. Well, on TV, they have, you know, one episode, you know. But even if you work a case for months and months, at some point, you got to run down these facts and you look at your buddy and you say, what do you think? And your lieutenant sitting in her office, you say, Lieutenant, let me show you what I got. And sometimes we say to each other, I don't think you have enough.
Yeah.
Other times we look and go, dude, I'd taken a warrant 30 days ago. I think you have enough. But again, law enforcement runs from a position of incomplete and conflicting information always. And to me, I think that's what Graham versus Connor, what the court was talking about, with that hindsight.
Mhm.
When you recognize there's going to be a disparity between the complete bright light of the truth with all facts known, as opposed to the officer responding and having to make a decision, it's unfair. It's completely ridiculous. It makes no sense. And it sets up a situation where we're seeing where good people will not be attracted to law enforcement and very good experienced people will pop smoke and leave.
That's exactly right. And I know we are seeing that. You know, this idea that this to use your example, right? So at a certain point, you have to decide to put your name on the dotted line of that warrant application.
Exactly.
And you go take it to a judge. Well, the judge that's going to decide that has absolute immunity, and you don't.
Yep.
And you got to remember that.
You know, it's really funny. When I used to teach a lot of search warrants and affidavits in the police academy, I would tell people, remember when you're putting information down, have somebody else look at it. So what do you mean? It's like, well, okay, let's say you do a search warrant.
Mhm.
Have somebody else look at the street numbers. Make sure the street numbers are correct.
Right.
Check the tags, check the VINs, check everything, because those are where we make mistakes. We're human, we make mistakes on details. And they say, well, the judge will sign the warrant. It's like, of course, the judge will sign the warrant. The judge has an obligation to make sure there's probable cause, but the judge has absolute immunity.
Right.
If the judge makes a mistake, they're going to look and go, well, you should have checked it.
Right.
So that's a perfect example of that intersection.
Yes, it is.
So you had some other issues on immunity?
I think I have covered. I know you're going to talk about state law immunity or state criminal immunity.
Yeah, so you know this issue of state law criminal immunity, and I just did an interview today with a television show. I think it was actually a radio show now, and I'm going to put it on their podcast. And I have a face for radio, so I thought that worked out pretty well that they used me. When we're seeing this issue of prosecutors reaching back to cases that are years old. We actually have a case right now where an officer was indicted 5 years, more than 5 years after the events unfolded. And you say, well, how can that happen? Well, we had COVID extensions, and everybody says, well, it's impossible to go back. What's the statute of limitations on murder?
I don't think there is one.
Yeah, you know, I seem to remember that's the exception in law school, that there is no statute of limitations on murder. So there's this concern that a shooting occurs, let's just use deadly force, shooting occurs, and the case is closed, it's been investigated, and then a new DA comes in and decides, well, you know, I looked at it and I don't think that's appropriate. Used too many rounds, used too many bullets, person had some reason to excuse the criminality of their conduct. They had a mental health issue. That's why they were coming at the officer with, well, you've had a sword.
Yes.
Mine, and I thought they were teasing me. Mine had a bow and arrow. I got a call to a shooting one time, said somebody shot a bow and arrow at an officer. I'm like, are y'all just making this stuff up? So we've had hatchets, hammers, other farm
Swords.
Implements. Yeah, nobody swung a tractor at anybody yet. I think that's probably the next call.
Yeah.
I'm not on call this weekend, so I guess maybe that may be you. But, you know, we've had this situation where this second guessing comes up. And then, you know, within this trial strategy about qualified immunity, I think it's important to talk about this concept of de-escalation. This notion of saying, well, an officer should have de-escalated, and therefore, since they didn't, they should face a grand jury and they should be prosecuted. That just doesn't square with Graham to me.
No, not at all.
Especially the fact that de-escalation is an outcome, not a strategy. You don't reach into your bag of tricks. So, hey, did you bring your de-escalation? I forgot mine. Mine's back at the precinct. Mine's on the charger.
That's right.
You know, de-escalation is a set of tactics, and we didn't call it that.
No.
What was the one in the verbal judo?
Verbal judo.
I always loved verbal judo. I had this idea of this guy like throwing words out like a courageous cat who's going to knock somebody down. But, you know, this concept of explaining in the moment what was going on the side of the officer's head when they're facing a look back. And sometimes, you know, we all get mad at prosecutors sometimes. But, you know, they have a difficult job too. They have to make a judgment call, and they're answerable to the populace. But, you know, sometimes they have an honest dispute. They say, look, I can't reconcile this. I'm going to toss it to the grand jury. And you had one recently.
I did.
How recently?
Yesterday.
All right. Well, tell us a little bit about that.
So I had a client. We went for a grand jury. He was a brand new rookie officer, been on the road 2 days. 2 days.
2 days.
Gets involved in a chase. His FTO was driving. He was not. So he wasn't even.
Well, you know why his FTO Because FTO was driving. You know why, right?
Why?
Nobody lets a second day recruit drive the police car. You got to earn that.
Yeah, you do. You do. So anyway, very brief chase. Car overturns. They go to approach the person who's driving the car, who's now in this overturned car because they couldn't navigate their turn. And the initial facts, this guy shows his hands, but then he retracts one and reaches down somewhere where they can't see, and then pulls his hand back out and punches it out towards the officer, and he fired. He's on the road 2 days. He's less than a month out of the academy, and I would say he did what he was supposed to do. But does it look bad on video? Absolutely.
Yeah, and let's go back in this context. When you say he did what he's supposed to do, 29-year law enforcement officer, 4 signs trained.
Yes.
Go get 4 signs trained. 4 signs trained, also firearms instructor,
Yes.
academy director.
Yes.
In hindsight, people could say he made a mistake. He should be prosecuted. So what happened with your grand jury? Now, Georgia's a little different now.
That's
In
right.
2016, I'm very proud I was involved with that process. We maintained the ability of officers to speak to the grand jury. Not every state has that ability. Some do, some don't. But our officers in Georgia, and it's not just officers, lest I say officers and say, well, they're getting special treatment. So if you're at the coffee shop listening to this and thinking that you know what's going on before you get on social media and start screaming and hollering, any public official who is brought up in a grand jury for conduct relating to their office can speak to the grand jury. So that's what you did yesterday.
Yeah, we did. And that process is pretty interesting in Georgia. And we all appreciate the work you did on getting that there. It requires a couple of things from the prosecutor. It requires them to notify them of the legal requirements in Georgia to notify the grand jury. It's been my experience the way they normally do that is they print it on a piece of paper and hand it to them, so here y'all read this. Which doesn't
I see them actually have them read it too.
Well, and that's good, and they should.
Yeah.
But you know, how many grand jurors are going to do that, and how many of them are going to understand what they read?
All right, just so inside the house, when we were having this conversation in this small committee, there were some prosecutors in there, and they said, believe this, they said the prosecutor is under no obligation to tell the grand jury the law before they make a decision on charging someone. And my answer was, what I would like you to do is record that and listen to yourself saying it.
Yeah.
That you're not going to tell a grand jury about justifiable homicide of use of force in defense of self or another before a grand jury makes a decision on whether to charge an officer with murder. How would they know? From watching Starsky and Hutch?
Yeah, exactly. And if that is where they think they know it from, we're in trouble.
Yes, we're all in a lot of
We're all in
trouble.
trouble.
That's part of the problem that we're in right now.
So, you know, part of our approach to that, and we spent a lot of time with this young man to get him ready for this. We help them prepare their statement. It's usually quite lengthy. We make sure that they explain in detail why they did, and not just why they did what they did, but the legal underpinnings from it, because we know they're not going to hear that anywhere else.
Right.
So especially in some ways, it was probably easier because he was so fresh out of the academy. I think he had a really good grasp of it. But that's what we did. We went in, he gave his statement, and a good portion of that statement was him explaining how this law and the immunities he does have under the law, you know, that he acted in compliance with them.
You know, and
he did a really great job.
Yeah, and it's really interesting. You and I have talked about this before, about some of the people who were screaming and hollering about law enforcement should never be able to talk to a grand jury. I actually look at it the other way. I think grand juries have a right to hear from their law enforcement officers as to why they used force. So if I was sitting on a grand jury, and I almost say, I'm hesitant to say I never have, because that's kind of saying I hope tonight's quiet, right? Because I'll get a grand jury subpoena in the mail tomorrow. But you know, the grand jurors, and when we've sat in dozens of grand juries with clients, and you know, what's really interesting is you see there's some people with the arms folded or growling.
Yeah.
But the vast majority of them sit forward. You see them when the officer comes in, they sit up a little bit and they lean forward. They want to know what's going on, because I think they want to hear from not just this officer who used force. They want to hear from their community police department. They want to hear from their sheriff's office. And I found them fascinated, because sometimes they'll talk to us afterwards about how much training officers get.
That's right.
And we just had a boost in training in Georgia, right?
Yeah, the police academy is going to be nearly doubling. I forget the number of
Yeah.
hours that it's moving to.
We don't do math on the show.
No,
No,
not in
no,
public.
we're lawyers.
Anyways.
We don't do math. So
Um,
yeah, it's basically doubling the amount of hours that officers get. And it's kudos to our state Peace
right.
Officer Standards and Training Council and their director, Mike Ayers, for pushing that type of advancement. And I think that we're seeing that. We're also seeing some crazy things like law enforcement needs more training and then trying to block the building of a training center. But that's another webinar, I think.
I've never understood the whole defund the police thing. If you want conduct to change, why are you going to reduce their training?
Well, I look at it this way. So defund the police is the fastest conceived, implemented, and failed social policy in United States history. So at least they have that. They're famous for something. All right. So they're dying to know how to come out.
We got a no bill. So my client went home with a much easier conscience last night.
Now his agency supported him.
They did. I really do have to give kudos. He worked for a local sheriff's office. And the sheriff was very supportive of him. His command staff was very supportive of him. Their training unit was very supportive of him because he did what he was trained to do.
And, when we have officers that are facing these types of situations, a lot of times what you find is that the grand jury really put a lot of emphasis and faith in what the officer said and what they felt and what they perceived and what they believed, even if their perception and belief was incorrect in the moment.
That's right.
And
that
I think
was particularly important because this suspect was not armed, but he gave every indication that he was.
And this is another interesting thing that we talk about when now we're talking about criminal immunity, but when a grand jury, you've heard the term, I know in all your writings, that the grand jury is the conscience of the community.
Yes.
So when the grand jury turns around and says, hey, we believe this officer acted appropriately, that should carry a lot of weight. And we shouldn't, if we're an agency, we should put out press releases about that. And a grand jury looked at this. They heard all the facts. The other side of that is, Scooter, you didn't. So stop complaining about it, on social media.
Right.
The grand jury heard all the facts and they made a decision. So I thought that was very, very powerful. And those of y'all that have listened to me for a long time know that I am not a fan. Is that strong enough?
I think so.
I am not a fan of citizen review boards because they're called grand juries.
That's right.
And a grand jury can hear a matter outside of an indictment. A prosecutor can bring things to a grand jury and say, what do you think? It's their grand jury. And we see over and over again when grand juries actually get a chance to hear all of the evidence, not just some of it, that when they get a chance to hear all the evidence, then they generally make a good decision. They want to make informed decisions. But I think the other thing that we get to the criminal immunity, and this is what happened in Georgia with criminal immunity, is recognizing that when the grand jury either doesn't hear the proper information or is spun up a little bit, or the grand jury is not told the law and they make a decision, there needs to be an ability for the officer to stop that train before they get to a trial jury. So in Georgia, we have a statute, 16.324.2, and we're going to put this in our notes, 16.324.2. And that statute was really designed and it was created during the Stand Your Ground law, the rights of citizens to carry firearms. That's really kind of where that law was gained a lot of ground and people realized what it was. There's a separate Stand Your Ground law that's recognized in Georgia, but this statute allows anybody who's charged with a crime to argue that they used force to protect themselves, a third person, protect property, obviously not deadly force, protecting property, stopping a felony, stopping a forcible felony. I used force to protect myself, a third person, or stop a crime, so therefore I shouldn't be prosecuted.
That's right.
Full-blown hearing, full-blown opportunity for the judge to hear witness testimony, which they may not hear in the grand jury, to see exhibits that the DA may not have decided to show. And we've seen this, and we've had cases. You can see our YouTube channel. We have a case called State versus Larscheid, and that was a DeKalb County police officer, and it's Larscheid. We didn't pick somebody whose name was difficult to spell, easy to pronounce, great folks, great family. But that case actually went to the Court of Appeals. And if you go to our YouTube channel, you'll see the oral argument there. But what was missing from the Georgia statute, kind of getting full circle back to our qualified immunity, was the ability of the officer to say, I used force to make an arrest.
right.
And wrapped up in this concept of the officer doesn't have a choice but to act, there was a gap in the law that if the officer just used force to make an arrest and they were prosecuted for the force they used, they weren't able to go back and say, look, I'm entitled to immunity because I acted appropriately under the law, according to my training, according to what the statutes of the state of Georgia say I could do. So I don't do rules well. I don't like being told no well. So we had some very, very gracious senators and representatives who helped us out. And on May 2nd, 2024, Governor Bryant Kemp signed the changes into effect. And I would highly recommend you look at this. The bill was SB Sierra Bravo 517, and that modified OCGA 16-3-24.2. So it's Sierra Bravo 517. And it added the law enforcement justification for use of force. It was already packaged.
Right.
We just added it to that immunity statute. So we've been contacted by several people throughout the United States. How do we do that? How do we add this to our, quote, stand your ground law? And I think it's going to have a big effect going forward.
Oh, absolutely, it will. And it's, it was kind of shocking to me, actually, in looking at how the state of the law before that is you had this one statute that said that you could protect yourself, you could protect others, you could stop forcible felony. That applied to anybody, by the way. It wasn't specific law enforcement, and the standard wasn't specific law enforcement. And if you were charged with that, you could then claim immunity to try and cut off this prosecution, because lengthy prosecution takes your time, takes your money, takes your peace of mind. There's really good reason to short circuit that if there's not a good reason for it. But yet you have the other statute that allows you to use force as law enforcement officer to effect an arrest. And you could make no such claim on that. And as an academy director, we taught both of those code sections for years.
It'd be negligence not to. You have to drill it into people.
These code sections will protect you. And in reality, they do, but one much more so than the other.
Right. And it was interesting because prior to this statute being passed, you could raise them with a jury.
Sure.
With the jury charge. So you would have your entire criminal trial. And when the jury's getting their jury charge and they're being told by the judge what the law is, that would be one of the things they were told.
Right.
And it's, it's really interesting in looking at how this was perceived. The lesson for the law enforcement officers listening, in 2024, we were able to get a law enforcement positive immunity bill through the legislature. Don't give up.
Yeah, that's huge.
The public supports you, overwhelmingly supports you. And the legislators, when we talk to them, support us. And this is the example that I used with a lot of legislatures, because I was down there a lot speaking to a couple of different panels of the legislature. And this is the example I used. So you have an officer gets dispatched, deputy gets dispatched to a house, and they see a woman sitting on the porch, broken nose, swollen face, crying. What happened? Because the officer was called to the dreaded trouble unknown.
Yes.
I don't know, someone's screaming on the 911 line. Well, it's not the 911 operator's fault. They don't have anything else.
That's
and
right.
What are they going to do? Tell you, well, we don't have anything, so just go in service. You can't. So the officer gets there.
No.
What happened? Well, she says, well, my boyfriend beat me up. He's in the house. All right. Now, what's going through the officer's mind? Kind of getting into this immunity. Well, is he armed? Does he know I'm here? Is he coming out to finish trying to kill her? Is he going to kill me? These ambushes we're having. So the officer sees the subject come out and says, hey, did you do that? He says, yeah. Well, the officer says, you're under arrest.
Yeah.
Reasonable, right? The victim has said he did it. You've got clear marks on the person's face that indicate a battery and maybe even an aggravated assault, depending on how bad the injury was or what was used. And I think the other issue that we have is this whole concept of what does the officer do at that point?
Right.
And I said, so the subject looks and says, I'm taking off. I'm not sticking around. Does the officer let him go? Now, if you're the sheriff, what do you say if he lets him? No, what do you let him go? Well, now what happens if you let him go? Well, that's where that hindsight. Well, why didn't you just let him go? Well, because he could go into the barn and barricade himself. He could be running out, loose and run into an elementary school or a crowded building. So officers are supposed to minimize the risk to other people, even if they can't be sued for not protecting the public at large. That's what we do. So the officer tackles the person, he hits his head on a rock, and he's dead.
Yeah.
That's not unreasonable. That's not an unreasonable set of facts.
Right.
That
That's
could
right.
happen. We don't wrestle with people on mats out on the street. And I said, if that situation happens, that officer acting under Georgia law appropriately, not responsible for placing the rock, used a technique that was acceptable and should be able to seek immunity. And the legislature agreed. We had incredibly overwhelming support. And that is now the law in Georgia. OCGA 16-3-24.2. And I highly recommend you look at that. I think you also need to look at our YouTube channel. You'll see some other resources we talk about that. But a lot of this has to do with getting that the officer's impressions and why they're reasonable before the court. And this gets into some of our trial strategy. Like you said, talking to the officer, and for the lawyers here, those are tough conversations.
They are. And reaching back to something you said a second ago too, you were talking about, you know, that they should have the ability to seek immunity. It doesn't mean they're going to get it.
Exactly.
And that was one of the you know, the criticisms that I think we heard as this was going through the legislature. Well, you know, we don't want to grant them extra immunity. You're not. You're just requiring what the law already did. So yeah, that's absolutely true.
Really funny. So while we were in those debates, wasn't funny at the time. It's funny now. When we were going through those debates, there was a guy who stood up and argued against the bill. And I'm looking at someone who's sitting next to me, and I said, I don't think he's read the bill.
Right.
So one of the legislators looks and says, it ain't what it says. And his answer was, well, that's why I read it. And I don't know what you do with that. I mean, I just sat there and said, you know, I hate to say this, but I got nothing. I mean, I got nothing. Well, he came up to me, and this is where I said, don't despair. People, if you explain things to people, there's some folks who are never going to agree with you. They're not going to like law enforcement because they don't like being told what to do. But there's the vast majority of people understand why law enforcement's there, why we need them, and that, you know, that good people go into and stay in law enforcement. Came up to me in the hallway. He said, hey, can I talk to you?
Yeah.
I was like, yeah. I was like, okay, this is going to be either really good or it's going to be really bad.
That's right.
Pulls me over. He goes, hey, man, I misread it. He said, not only me, he was a lobbyist. He said, not only me, my entire group is in favor of this law. We have no problems with it. And this is the tagline. Here's the lesson. Words matter.
They do.
In the materials, and I'm going to credit my lovely, talented wife for coming up with these words. And you need to get the input from the community. And this is great. Yeah, she's ruined. She's been married to a cop and a lawyer for years. So I don't think she thinks like anybody normally anymore. But she said, you know, if cops follow the law, they shouldn't be prosecuted.
It's that simple.
Yeah. And what a simple way to explain it. And when we got pushback from legislators, I said, well, if they're following the law, should they go to jail? Well, no, but, and what it came down to, it looks bad on camera.
Yeah. Yeah, it does.
Yeah. Why couldn't they have done something else? A lot of these things that were rejected.
Hindsight.
Hindsight 50 years before we were dealing with the Supreme Court and Graham versus Connor. I wanted to see, do we have any questions, Leah? I know that we had a couple that have that people have talked about.
Oh, nothing in the chat as of right now.
So if you have questions, put them in the chat. If you have questions that you don't make to the chat, you can always email us. I know that we're on that list. You know, one of the things that I wanted to bring up, and it kind of gets to some fresh produce, if you will.
Yes.
Third Circuit Court of Appeals. So Federal Third Circuit Court of Appeals, case of Thomas versus Harrisburg. One of my favorite things to say in law, et al. I don't know who Al is, but this guy gets sued a lot.
He does.
You talk about somebody who needs to kind of clean up their act. I don't get it. So a lot of officers got sued in this case, and it's a pretty interesting case. And it came out of the Third Circuit, and we just checked. And how did we check? Because we have people that we are growing our own lawyers here at LoRusso Law Firm, because we've had a lot of people who didn't want to go represent cops. So now we're putting people through law school. And we checked, and the case literally has gone to the Supreme Court, and we're waiting on them to decide on cert. So the lawyers here, just take a deep breath, take a sip of your coffee. For those of y'all that are not attorneys, when a case goes to the Supreme Court can not hear it. They can look at it and consider it for a long period of time, or they can actually hear it where it gets to a full-blown opinion. Hundreds of cases seek cert before the Supreme Court. it doesn't mean they're going to be taken. There's a lot of criteria they use. There's probably some that we'll never know about. But one of the things they look at, it's almost like we're coming full circle,
Yeah, kind of.
is this tension in the circuits. So this is a case that I think you should watch. Like I said, Thomas versus Harrisburg. And the case is going up to the Supreme Court. I believe they'll probably wind up taking it. And it had to do with some officers who arrested someone, and they believed that he had ingested cocaine. Very interesting case. And that never happens.
Never.
No, and again, you're sitting down. I'm really glad. I'm glad you're just not really short. But this notion that officers should have treated this person differently because they were under the influence of alcohol or drugs. How often do officers deal with people who are under the influence of alcohol or drugs?
Daily.
Yeah, I actually said to somebody on the street, I was not always a shy and reserved when I was a street cop. I was outgoing. I actually said to somebody after the 15th time I'd been to their house, it's like, do you ever talk to the police when you're sober? Here's a test. When you're just sober, do the police show up in your kitchen? Maybe you're the problem, not us, because he was mad that we were in his kitchen. Again, it's actually, we said, why are you in my kitchen again? Well, clearly not because I wanted to be here. So this situation came up where the officers were dealing with somebody and they brought them to the jail. And the jail has medical personnel, and one of the ministerial acts, again, full circle.
Yeah, you got to do a medical check.
Got to do a medical screening. Okay. So jails, it varies, and I represented infirmaries for a long time, but the jails have varying degrees of medical personnel there, but they're all going to have somebody. It may be a nurse, maybe a paramedic, and in a lot of bigger jails, they actually have physicians there. And if they're not there, they're on call. So they're going to do that medical screening. That sometimes that medical screening is, hey, do you have any medical conditions? Yeah, I take high blood pressure medication. Well, do you have it with you? No. All right. Well, we need to get you your dose in the morning, or insulin for diabetics, things like that. In this case, they evaluated the person, and the nurses and the medical staff, it doesn't say specifically in the opinion what degree of folks were involved or whether there were conversations to specialists. But they put the person, they said, okay, he can stay here. And they put him in a holding cell, and then he died from complications of fentanyl and cocaine. Now, fentanyl is a dangerous drug. Fentanyl, you measure lethal doses of fentanyl in micrograms. I don't know what a microgram is, but it's not a lot.
Not much.
Okay. So the family sued, and the Third Circuit, raised this issue of the duty to intervene has been recognized in another officer using too much force. Okay, that's there.
Yep.
But the question was, is there a duty to intervene to get a certain level of medical treatment for a person? Now, in here, there were interesting facts. The agency's policy said that if you believe someone has ingested drugs, you have to take them to the hospital. So this is where we see the interplay of policy, which are guidelines. And as we said, the policies are not 100%, but it's something that goes to the objective reasonableness, right?
That's right.
Yeah, and you talked about the Monell liability. Is there a policy, pattern, practice, or custom? So in this case, the court said, okay, we're going to grant qualified immunity because the clearly established obligation to intervene in a medical situation has not been fleshed out well enough, and now it's on appeal.
That's right.
Your thoughts on that? From being an assistant shift commander at a jail, and
I mean, yeah, it poses a lot of responsibility on the arresting officers and the jail both at the same time. If this officer, if you've got an officer and he's got an arrestee that he thinks is in this condition, and there's a medical person at the jail, why should they think they should move forward? Because you've got somebody right there that should deal with it. And then on the flip side of that, you've got the medical person at the jail who is, exercising their medical expertise.
And what's that D word? Their discretion.
Discretion. Yes, discretion.
Yes, and judgment.
And exercising their discretion. And in fact, could, as you mentioned, intervene. They could intervene and say, and frequently did at our facility,
all the time.
We're not taking this person. They've got to go to the hospital. So, it's difficult for me at least, to kind of see how that falls back to the officers at that point. And as far as the expertise at the jail, how much leniency do they get? You're better able to speak to that than I am. But when they exercise their professional judgment, what kind of liability should that incur?
And for about 18 years, I did medical malpractice defense for a very, very large healthcare system. And this is another thing that I think courts are good at and the public's terrible at.
Hmm.
So you say, well, this guy had taken drugs. How many people are arrested on a regular basis that have taken drugs?
Yeah.
I'll use two examples. When I went to intoximeter school a long time ago, you didn't even plug it in. You just cranked it up on the side. So a long time ago. There was a judgment call being made in some jurisdictions that if a person came, and now we were going to be the ones that actually telling the officer, hey, this guy's a point, whatever.
Right.
And, you give them a little slip. So this is what the person blew into the machine. At certain levels, this person should be brought to a hospital. And I remember having this conversation. Does it matter what condition they're in? And somebody said, well, what do you mean? It's like, well, are they able to sit up?
Right.
Are they having a conversation with you? And I remember, I think the highest person I ever arrested for DI was like a 0.36. And by the way, in morning rush hour traffic. And I brought him to the jail. There was no such policy there. And one of my buddies said, I heard you got a 0.36. And I said, yeah, he goes, where is he? He's looking on the floor. I said, he's standing over there talking on the phone.
Yeah. That's right.
So this tension of whether officers should drop someone off at the jail or bring him to the hospital has been going on for a long time. And
That's right.
I'll give you another example from a medical case. And I think this is one of the things that we do well here at the firm, and we talk about in the Force Forum, we talk about the Blue Line Lawyer Institute, is bring people in from the outside, bring in those outside experts. If you're the lawyer defending this case, go find a medical examiner, go find an ER doc. And I'll give you an example of a case that I had where the doctor was criticized for treating a person with a blood sugar of 200. Well, that's kind of high. It's not, you're going to die high, but it's high. Well, I went to an endocrinologist who dealt with people he had a career in a small community, great guy, fantastically compassionate doctor. All of his patients were problem diabetics. And he said, if I sent everybody to the hospital that had a blood sugar of 300, I'd never have anybody in my office. Yeah. So there's this dose of reality that needs to come into these cases that I think came in very well in 1989 with Graham versus Connor. And we remember with Graham versus Connor, you remember what they did at the end with the guy?
Yeah, let him go.
Yeah, they let him go. They brought him home. They said, hey, we got the wrong guy. Our facts were wrong. So, they brought him home and he eventually sued because he had been tackled and he had some injuries. So looking and incorporating all these different tests, one of the things that came to me was a legal concept. You can find it. I'm going to geek out here. The lawyers will like this, but I'm going to geek out here. But really, the law enforcement, please, and trainers, please follow up. There are all sorts of legal defenses that take place that we don't talk about in the police academy because we have enough to talk about the police academy. Right. And one of them is proximate cause. Did the officer cause the injury? Now, when you're talking about immunity, we generally don't get to that, okay? But in this case, I think you're going to see a tension in the law, and this may be why the Supreme Court takes it. There is a concept called the learned intermediary doctrine. And the example that I gave when we were talking about this, doing the prep for the show, yes, we did prep,
yes,
is if a doctor makes a mistake, a typo on a script, and they give it to the pharmacist has an independent obligation to read it. They can actually read doctor's handwriting. Isn't that shocking?
Wow.
I think that's what they teach about.
That must be all the years of
That must
education.
be half of pharmacy school is how to read. So if they look at it and they say, something's wrong with this. It's either the wrong dose or, hey, this patient's taking a drug that might be contraindicated. So what do? Pick up the phone. They call, hey, did you mean to write this? Or is it a bad script? Or, did you just have a typo? Or did I make a mistake reading your writing? In one case that I did a case study on was a drug called tamoxifen, where there was a decimal place misplaced, and it actually killed the patient. So it was a situation where the pharmacist wound up being in trouble because they didn't properly stop the causal chain. They didn't prevent the injury. Right. So I think this is where you're going to see this tension of constitutional torts, criminal law, training of law enforcement running up against this issue where is the officer in the best place to determine what type of medical treatment the person needs, or is the medical staff of any level in the best condition? And the court talks about the fact, number one, that the nurses did evaluate the person. But keep in mind, at this stage, they have to accept everything the plaintiff said is true. So there's a little bit of difficulty trying to second guess the facts in the record. But I think the other issue that comes up is, policies aside, officers make these judgment calls all the time. So if they made the decision to drive to the hospital, and it's my scenario, so
Sure.
I'll make it this way.
Sure.
It actually is not too far from where you and I
That's right.
policed. You have a jail that sits here. You have a hospital that's 10, 12 miles away. What if they die on the way to the hospital?
Yeah.
And this duty to render medical aid, not care, not some sort of treatment there, but the duty to get them to a higher medical aid, I think is going to become a bigger issue. And I think it's a case to watch. Again, Thomas versus City of Harrisburg. I think one of the reasons to watch it is we have so many people who are victims of drug dealers. And if you're going to have a conversation with me about legalizing drugs, just save your breath, because I've seen it kill people. I've seen it destroy families, and it's a scourge on our community. But, officers are the ones that wind up handling these cases, trying to de-escalate people who can't communicate, won't communicate, don't have the physical or mental ability to communicate, to effectuate any change in behavior. And then when they take them into custody, what do you do with them?
Yeah. And there's a big implication for the public safety at large too, because you get a situation like this. And as I understand the facts of the case, he wasn't exhibiting any distress. There was nothing wrong with him. And they take him to someone who's supposed to be a professional, who they should be able to rely on, and they explain what happened and they take custody. Well, if every time you have a circumstance like that, you have to go to the hospital, it takes time. Got to go to the hospital. You're gonna have to wait.
Right, because
You're gonna have to
you
wait a
can leave
long
them at the
time.
jail.
You can't leave them at the
You
hospital.
can't leave them at the hospital. They're under arrest.
And by the time, and so what happens in the intervening time? Well, it means that officer's not out patrolling the streets and protecting the public. And in a small agency, that could have a huge impact. Even in a larger agency, it has an impact. So, what is the ultimate impact on the public safety at large if you're going to enforce that kind of requirement?
Yeah, and I think you're absolutely right. And I think this is a case to watch for several of those reasons, not just because I think a lot of officers get placed into this. The other reason is, in looking at the case, I'm just going to hold this up. This is the list of people sued. So the medical facility that staffs the jail was sued, the individuals are sued, and then they have what are called John Doe defendants. For those of y'all that don't practice law, you put those placeholders in, said, we don't know who they are. Or as we say in the South, we're fixing to sue them.
Yeah, we're fixing to.
Or, it legitimately, we don't know who they are yet, but there's somebody that's been unidentified that we believe should be sued. So we're going to put them in there. It's a case to watch. I think it's going to be a very interesting oral argument. It's going to be very interesting policy implications, as you said. And, from a position of a person who had to, for lack of a better term, I don't mean any disrespect when I say this, you send a deputy up there to babysit somebody who's going to be there for hours, and really they may not be dangerous. They may not be whatever, but if they're at the jail, if they're at the hospital and they're under arrest, a law enforcement officer has to be with them, whether that's the officer who arrested them or the agency who took custody of them. What's the longest you've had deputies sit up at a jail waiting for someone to be evaluated, or at a hospital?
Hours.
Yeah. I mean, y'all get in and out of the ER really quickly, right?
Yeah.
Yeah. So you go to the ER, it's the same thing. Another thing important about this case that I'm hoping the Supreme Court takes it up. There were two issues that they said were important. Number one, the guy had white powder on his lips. And second, they said it was 46 degrees and he was complaining he was hot. Well, those are equivocal signs. And, did he ingest cocaine? Okay. How much cocaine did he ingest? Have the officers ever seen that before? That sounds a lot like a hindsight analysis.
Yeah, it does. It does.
Yeah. So it's going to be really interesting to see. So any questions up in the chat?
Yes.
Awesome.
So one kind of a multi-part.
Okay.
Under SB 517, who will decide whether the actions were justified? Who will clear them? What is going to keep a rogue DA from going after an officer?
Oh, awesome.
That is great.
You want me to take that?
Yeah, go right ahead.
I love this bill. I wrote it.
I know.
I do like it.
That's why I figured you ought to take it.
All right. So the first question is, who will decide? This was a big issue when we were having this discussion. So there was a concern, as you said, that this statute was a magic wand.
Yeah.
I file for immunity and I'm gone. It's not that way with any type of immunity. Absolute immunity, qualified immunity. It has to be decided by a court. And this will be decided by a court. So the way this would work is the officer, and if, you know, you talk about rogue DAs prosecuting people, nothing's going to stop that. I just did that interview about that today. It's a problem all over the United States. Our force forum last year was political prosecutions just because of that.
That's right.
The officer gets charged. And when the officer gets charged, whether it's by an indictment or whether it's by some people call it an information, we call it an accusation in Georgia. When the officer gets charged, they have to file a motion. They have to physically ask for this immunity, just like a private citizen would if they shoot somebody who tries to come in their house in a home invasion. That case has to be heard. That issue has to be heard prior to a jury being impaneled. So the judge has an obligation, and there's case law that says if they fail to do this, the conviction can be reversed. They must hold what we would call a full and fair hearing, where the state can call individuals. That was another question: is the state hamstrung? No, they're not. They can call whoever they want. But the critical thing is the defense can call whoever they want. The officer can testify. The trainers can testify. And we have had cases where the officer's trainer, I know this is scary, the officer's trainer was never asked by the district attorney whether the officer acted appropriately.
That's right.
And in that Larshide case, we had two people that testified. We had about 6 witnesses. 2 of the individuals who testified were the officer's trainers, who not only said, I trained them, they watched the video and said, that's appropriate, that's lawful, and even more, because you got to have things in threes, right?
Yeah.
Yeah, even more. That's exactly what I told them to do.
Yeah.
So that's how that would work. Now, the other legal part of this, if the judge issues an order saying the officer acted appropriately, just like the private citizen with the home invasion, the charges are gone. They are dismissed as a matter of law. So it's very, very powerful. I would say it's probably the biggest thing to happen in law enforcement about the past 60 years in Georgia.
I agree.
And I'm very honored to be a part of it, but I've really been humbled by some people actually telling me that they're going to stay in law enforcement through their 30-year mark because they feel like they now have a chance.
That's right.
Those are
huge, and it's very true.
Very true. That, and when they're looking at money to spend, defending a murder case. If you can defend a murder case for $100,000, I'm shocked.
Yeah.
And I have seen people pay well over $1 million to defend a murder case, but $500,000 is not uncommon. So that's why we should do another FOP plug. FOP Legal Defense Plan, FOPlegal.com. Get it. You wear your vest, you wear your seatbelt. If you don't wear your seatbelt, you're an idiot. Wear your vest, wear your seatbelt, kiss your family when you come home, and get the legal defense plan.
We do have a follow-up to that.
Follow-up?
Yes.
That's 2
Right.
questions from one person.
Would that be the same on a civil suit against a Leo?
Yes. So when we got the statute together, you read that 5111.9. And this is important for those of y'all that are thinking of doing this in your state. Call us. I'll help you. I'll come out there and help you. Whatever we can do to protect our officers nationwide, we need to. We took the statute 16324.2 and we inserted already existing statutes that allowed officers to act. So not only can it be used in a criminal case, it can be raised as a civil case defense under 5111.9, and we'll post that. That's the one that you read from before. So you can bring that up in a civil case and say, hey, what I did was appropriate. Now, we've been asked the question, does that only apply to state civil claims? And I'm going to give the answer that everybody knows lawyers give.
It depends.
It depends. Actually, I'm going to give the one that nobody ever expects lawyers to say. I don't know.
I don't know. Yeah, that's true.
We'll find out. And I think you're going to find a lot of people raising it. I think you're going to find a lot of people looking at it. But here's the bigger effect. So let's say you have a mix of state and federal claims that are filed against an officer in a federal court, and you raise this issue of immunity under 16324.2. What's the judge going to hear?
The same evidence.
Yeah. And a lot of it.
A lot of it.
Now, this is going to be different than just, throwing a brief in for summary judgment or a motion to dismiss. The judge is going to hear live testimony evidence. And if they have a substantive right, a procedural right to bring this information before a court, the judge can't unhear it.
That's right.
So all of that evidence, and yes, it's the state statute, but all of that goes to the objective reasonableness of the officer's actions, that they acted appropriately under state law. They acted appropriately under their training. They acted appropriately based on the circumstances they had. I think it's going to have an effect not only on the any state claims, but I think it would necessarily have an effect on not only the judge ruling on the qualified immunity or other types of immunity, but also on these appellate courts.
Yeah.
Because remember, the appellate courts, as we say, they review a cold record. It's not in the record.
That's right. It's not there.
There's nothing there for them to look at.
And on the criminal side, we've already seen this with supremacy clause. Yeah. Of course, here's supremacy clause, and you can also make the state claim for immunity under state law.
Yeah, absolutely. And I think that this is something that is going to take a little while for people to jump onto. And like I said, if we can be a resource for people, we're happy to. We get involved in cases in other states all the time. Sometimes it's just to help advise lawyers how to cross-examine experts, because just because someone's an expert doesn't mean they're an expert.
Exactly.
We have seen some people recently testifying as experts that
like the one that didn't know who the 11th Circuit was.
the one that didn't know the 11th Circuit was. That was probably my favorite. Also, I think my favorite quote was something about Fourth Amendment law not changing in 40 years.
Yes.
I think the Supreme Court would probably disagree with that a little bit.
I'm sure they
But,
would.
just because someone's an expert or just because you've been given an expert report, you need to challenge it. You need to look at it. And if we can help you with that, or we can help you cross-examine their expert, because between the two of us, we're old. We have a lot of law enforcement. We probably have over 65 years of law enforcement experience between the two of us.
So you didn't do math, man.
I know. I made a mistake. It wasn't true. And like I said, bring in the experts like Force Science that we do so often.
Right.
We've had Dr. Lewinsky speak at our Force Forum every year. So we have a few wrap-up things we'd like to get through. And before we go through our wrap-up, I'm going to take things a little bit out of order. So the last thing you hear is not a disclaimer. Ken, hit him with a disclaimer.
I don't have another disclaimer.
You don't have another disclaimer. There you go.
Okay. Disclaimer: the information provided on this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials presented are for general informational purposes only. Any references to state law are for illustrative purposes only, and you should contact a licensed attorney in your state to obtain advice with respect to any particular legal matter.
As a couple of reminders, thank you, Ken. Very well done, by the way.
Thank you.
I felt disclaimed.
I do.
Did you? People
I do.
disclaim me all the time. So, one of the things that I wanted to point out, obviously people are, if they're signed up for this webinar, they'll be signed up on our Blue Line Lawyer Institute newsletter. You'll get information about the Force Forum, which will be down in Jekyll Island. They were great. The Jekyll Island Convention Center was great to us. We had about 150 people from about 16 states that signed up, and it was fantastic. We appreciate people giving their input and spending their dollars to come to our training classes. So it'll be next spring. The dates will be set very shortly, so please keep in mind where we are. You will get a link for all of these materials that we're going to be putting up, and if anything else comes up that we think about or that is important to us, we'll put in there. We'll put a copy of the Thomas case, because I know a couple of folks probably want to read that. And then, so far as the Blue Line Lawyer Institute, we have a couple of slides that we wanted to put up and tell you a little bit more about what we do. The Blue Line Lawyer Institute was created as a think tank for law enforcement officers and their families. Law enforcement and their lawyers. We don't let people come to our Force Forum who are going to sue police. They can go to somebody else's company.
That's right.
And I had a couple of them say, well, you'll make more money if I come. Well, if I want to make a lot of money, I'd still be representing neurosurgeons. Cops don't have any money. Great people. We love them. They don't have a lot of money.
Yeah.
So how do you plan now in case you're investigated, sued, or prosecuted from using force or injuring someone? The FOP Legal Defense Plan, foplegal.com. Yep. One more.
Yeah.
373,000 law enforcement officers are part of this organization. The amount of money they have spent defending people in more than one case, well over $1 million. In one case, I think they're over 3 million.
Wow.
Just for the officer. All I can say is it's heartbreaking when an officer has a good defense, but they come to us or they come to some of the lawyers on here. And for the lawyers that are representing cops, thank you. Thank you for taking care of them, because they're the best and the brightest we have. And God knows that they look out after all of us. but it's heartbreaking when they're going to have to put a second mortgage on their house, or they're going to have to do something to pay for criminal defense. And you don't have to. It's $324 a year, foplegal.com. If you are interested, you can go on our YouTube channel and you can learn a lot more about the LoRusso Law Firm and some of the things we've done. You'll see some very entertaining civil service boards we had from
Yes.
the city of Atlanta from a few years ago.
Those were fun.
Yeah, I've had more than one person tell me that they had some popcorn in the six-pack when they went to watch, but you know, we love what we do. The only people who like litigation are lawyers. So the people that were involved in it probably were not happy, but just the fact that we were able to stand up for them in a couple of situations when no one else was, or no one else was publicly doing it. Behind them, they had a tremendous amount of support. So you can go on there. And that case of the criminal immunity being argued in the Court of Appeals case is there. And not because my shining face is on there, but you'll hear the questions the judges asked. You'll hear the arguments of the prosecutor. And if you're going to prepare for one of these and recognize what you're really in for. You know, we fight with the red man in the academy.
Yes, we do.
We do that because we want to show the reality. We have students on a driving course killing cones, serial cone killers. We do that so you can make those mistakes and see how things work in the real world. If you're a police administrator or trainer, you've got to know how what happens and what you write in that police report, how it turns into the court case that the lawyers who represent you have, how it turns into that oral argument, how those judges, who the only thing they know about law enforcement, are they call them when they need them, and they can't start court unless they're sitting there next to them.
Right.
You know, you need to be able to get that information out. We have a slide about the Blue Line Lawyer Institute, and we have a QR code that you can download more information. Please make sure that you sign up for our newsletter so you can catch up on information. Also, we have our books featured here. All the profits from the nonfiction books go to law enforcement charities.
Awesome.
And one of them goes to firefighter charities, Firefighters in the Hot Seat. And, you know, people say, well, why do firefighters have, you know, internal affairs complaints? And I always ask people in law enforcement, I said, how many of y'all love the people you work with? And everybody raise their hands. How many of y'all want to live with them? And everybody puts their hand up. So firefighters get into disputes too. They get investigated. Yeah. So firefighters in the hot seat, we donate those funds. We've been fortunate enough to be able to make a difference in some people's lives.
Yes, we have.
And a couple of those books are on Parallax and Blue News, Parallax and Hunting of Men. Both of those books are on audible.com. And I don't read them. So we have really, really good folks who read them. The disclaimer is up there again, in case you didn't get it the first two times. I personally liked it better when you read it.
Well, I appreciate that.
Yeah, it's much better than reading it yourself. The last slide, you'll see Serve Others, Live Without Fear, and a list of our awesome attorneys. We have another one who's going to be joining us very soon. Yes. A 28-year veteran of the Cobb County Police Department who has finished law school. He did something that nobody I know has ever done. He started law school part-time at night.
Oh, yeah.
And then is finished full-time in 3 years.
Yes.
Never seen anybody do that. Very, very bright person. I would call him a young man, but he'll kill me. But I taught him in the police academy 30-something years ago because I'm old. But he is taking the bar in July and will be licensed very shortly and working with us. And we are thrilled to have him. And what's probably his first stop after he gets here? Force Science. And he will be certified. All of our lawyers are Force Science certified. Serve Others, Live Without Fear is the motto we live by here. It's a kind of a credo, if you will.
It is.
Our clients are facing fears that nobody in an office will ever know. And we have to find a way to serve them, find new ways to serve them. And we have to live our lives without fear, because when fear gets the best of us, we don't live our full lives. You'll see our website there. You'll see our information there that you can reach us. Any final thoughts?
I've enjoyed being here. This has been a lot of fun, and I hope it's been really informative. And we will have a lot of materials up. So if you ever have any questions, anything you want to know, if I can help you, I'm always willing to.
And for the law enforcement officers out there, first of all, thank God you're there. Absolutely. And truly, we thank God for you every night. But the other thing I want to tell you is the lawsuit should not be the most scary thing in your life. Responding to that holdup alarm, going to that domestic dispute, running through the woods when the temperature's dropping, trying to find that 5-year-old who wandered away from their house. Those should be the moments that get us to tense up. And if there's anything lawyers can do to help you live your lives without fear while you're serving others, we're going to do it. Thank you so much for joining us today.
Thank you.